My name is Max Sanderson, and I'm part of the managing editor's team at The Guardian. Boo. Yes. I thought I'd get in there first before it came from the crowd. Yes, they do know I'm here. And yes, I'm also here in a personal capacity. So get that out of the way. So working for a newspaper, obviously, contempt of court laws is something we come up against quite a lot. They play a role in what we can and can't say, what stories we can report, how much detail we can go into. So that's nothing new. I suppose the reason I sort of pitched this session to Claire and the team for this year's battle sort of really came to the fore around the Lucy Letby stuff that I'm sure everyone's very familiar with. Lots of journalists, including many of my own colleagues, had very sort of well-founded fears about the safety of the conviction, but we were not allowed to report them because there was an appeal going through the courts. And I suppose that in itself maybe isn't anything new, but the sort of kick in the teeth for us is when there was a quite well written, although I don't think I agreed with the sort of sentiment of it, an 18,000 New Yorker word piece about the safety of the conviction. And they sort of, tried to geoblock people trying to view it from the UK. Obviously, anyone with half a brain cell can go onto Reddit or get a VPN and read it. And I suppose from a journalist's point of view, not only is that annoying in terms of, we could have got a lot of readers' eyeballs on a similar piece, but also this idea of, reporting the truth. And I think often what can happen in these cases is you create a vacuum where people can sort of fill it with lots of different conspiracy theories or actual sort of well-founded claims, and the journalists and news organizations can't really do anything until the court case is over. And I think, Lucy Letby, obviously there's been others recently, the Southport murders, the Manchester airport attack, the shooting of Chris Kaba. And so I think, there's lots of questions. We've only got 45 minutes. I'm really looking forward to hearing all of your thoughts and questions, but also from my brilliant panelists. We'll talk a bit about what exactly it is. And I think, whether A, it's a good thing, B, is it fit for purpose in this modern age? So helping me to explore this, I'm really excited to introduce the panel. So in the order they'll be speaking, first up we'll have Professor Gavin Phillipson. He is a professor of law at the University of Bristol. And last night at the sort of festival drinks, we found ourselves sort of attracted to each other like two woke moths to a flame. And he sort of said, "Are you the guy from The Guardian?" I said, "Yes, how did you know?" So it's lovely to have you here, Gavin, a fellow ally. After Gavin, we'll have Helen Dale. She's a senior writer at Law and Liberty and also an author. Yesterday, she was sort of flexing her authorial muscles in a session on fantasy fiction. But as she told me just before, she spent more of her life as a lawyer than a writer. So a nice sort of balance over the 2 days. And then last but not least, we'll have John Holbrook, who is a barrister. He's a writer at Spiked, a brilliant writer at Spiked, I should say, and a critic for Conservative Women and a Battle regular. So please join me in welcoming. So first up, Gavin.
Thank you. Thank you for that introduction. I should say, actually, I'm very critical of wokery, but from a liberal perspective rather than a right-wing perspective, but I think that's also a growing tendency. So, despite being from the University of Bristol, I'm actually just going to play this with a pretty straight bat and just lay out what the law is, and then we can have the debate in the light of what the law actually is. It's quite narrow and specific. And my suspicion in relation to some of the information about this session is that the police have at times blamed contempt law for why they're unable to release details, information about a given suspect or defendant, when in fact contempt law has nothing to do with it at all. And it's never been the case, certainly, that contempt law prevents the police from releasing the details of a charge or a suspect's ethnicity or his age or anything else, as I shall explain. As a preliminary point, I couldn't resist this one. We should note that we actually owe the more liberal regime that we have now under the Contempt of Court Act 1981 to a judgment of the much reviled European Court of Human Rights and a case called Sunday Times versus the UK in 1979. It's often said by those hostile to the ECHR that we don't need it because we have the glories of the common law. Well, the common law in this area, before it was reformed following the Sunday Times case, provided very little protection for press freedom and was also very far from clear. And some of you may remember the Sunday Times case itself came about because that newspaper was issued with an injunction to prevent it from publishing what was admitted to be serious and balanced articles about the thalidomide scandal because of the fear they might prejudice civil proceedings that were then underway, although they were often described as dormant. That injunction was upheld by the House of Lords, our then highest court. Despite the huge public importance of that issue and the fact that the article in question that was injuncted was a solid piece of investigative journalism. So at that point, the law allowed injunctions to be granted where there was conduct, whether intentional or not, that was liable to interfere with the course of justice in a particular proceedings. There was no defined time limit, as there is now for the stage those proceedings had to be at. They merely had to be imminent, a term that lacked clarity. And not surprisingly, the European Court of Human Rights found that the injunctions breached the Article 10 right to freedom of expression. So the result was the Contempt of Court Act 1981, and that act made a number of key changes. So first, the contempt regime only applies when proceedings are active, and what that means is clearly set out in a schedule to the legislation. Essentially, the active period in criminal cases starts at the point of arrest or service of an indictment and concludes at the end of the trial. And during that period, the so-called strict liability rule applies. And under that rule, it's an offence to publish material which creates a substantial risk that the course of justice in the proceedings in question will be seriously impeded or prejudiced. So note that dual requirement. The risk has to be substantial and it has to be of serious prejudice. And applying that test, courts have tended to find the greatest risk comes from articles containing seriously prejudicial material that are published during or shortly before the trial. Where the trial is many months away, courts have tended to rule that even if potential jurors had encountered the article, they probably wouldn't recall it by the time of the trial. And I'd say there's been a pronounced trend in the case law since the 80s that's tended to raise the requirements for showing the risk of serious prejudice really is a substantial one. And then finally, even if an article does create a substantial risk of serious prejudice, there is a defence under Section 5 of the Act that applies to an article which is or contributes to a discussion in good faith of public affairs or other matters of general public interest, if the risk of impediment or prejudice to particular legal proceedings is merely incidental to that discussion. I don't actually think that wording is very helpful. The term incidental is a bit of an odd one. But the idea is not to criminalise articles that are seeking to highlight matters of serious public concern where the prejudicial material, where the focus on the upcoming trial is not the main one. The final point to note is there is a residual common law offence in this area and preserved by the Act. This only applies to intentional contempt. So those cases where courts have found that articles were intended to cause prejudice to legal proceedings, which means at least that the editor must have foreseen that the suspect would almost certainly not receive a fair trial as a result of the publication. Rather than, as under the statute, a substantial risk of serious prejudice, it only requires a real risk, and as before, it applies to proceedings that are imminent, as well as those that are active, and a term that the courts have still really failed to clarify. Because of the requirement of specific intent, it's very rarely prosecuted, in fact, but I'm afraid it is another area where the common law rather undermines the protection for press freedom provided by Parliament. So from what I've said, I hope it's clear that the simple release of factual details about a suspect, name, age, ethnicity, nationality, etc., could never amount to contempt, since in themselves they pose no risk at all of prejudice in proceedings. Also note, as the thing says, the Law Commission is currently investigating this area and may recommend reforms, perhaps shortening the active period and reforming the public interest defence. I'm sure we'll talk about that. Thank you.
Thank you, Gavin. Really brilliant introduction there. Helen.
Gavin's given me a good lead-in because my time at the bar was spent in Australia, which has the older system of contempt of court. So I've had basically the influence of the law of the United Kingdom in Australia ended completely in 1986 as a result of the passage of the Australia Acts through both the United Kingdom Parliament and the Australian Parliament. So you need to imagine what the law was like in this country in 1986, and then you get quite a good picture of what Australian law is like. And then you also, and this is one of the reasons why that legislation was enacted, you also have to rip out anything from the European Union as well. When Australians complained about the European Union stuff appearing in Aussie law, in English law, and they didn't know what to do with it. They weren't criticising the EU. They were just saying, this is no point. This is useless to us. We have to stop this. And so you get a picture of an older world, what I'm going to describe to you. Now, the underlying logic of contempt of court in Australia has always been, the core of it is to protect juries and to protect individual jurors as well. So you hear the stories about you can't report this aspect of a trial, or you can't say this about this person, or so on and so forth. And you sort of think, well, what's that got to do with the jury? And that's actually a relatively unusual application of the law of contempt. I will give you a story of a much more commonly application of the law of contempt when I was a pupil barrister, which is when you're sort of little baby barrister and you're just starting out and you're in the chambers and you work for a QC or a KC these days. One of the things that you can do with a jury that's been impaneled and during the course of a trial is take them to the scene of the crime, basically. And the technical term for this in the law is known as a jury view. And what happened, and there's all sorts of very strict rules about jury views. You cannot have, for example, counsel can't talk to the jurors. If the judge is there, any comments that must be made to the jurors must be made by an officer of the court. In this country, it may be a bailiff or something like that. In Australia, or the United States, it's a court official. In Australia, called an associate. In the United States, called a law clerk, who has to do this very, very strict rule. Anyway, while I was a pupil, what happened was a local TV crew, and I was a barrister in regional Queensland, a local TV crew decided to film all the jurors while they were walking around a location where there had been allegedly a murder had been committed. And not only filmed them all from a distance, so people were a bit suspicious there was something funny going on, but you couldn't really see. But of course, modern cameras, they could film up my nostril from the back of this room if they want to. And anyway, it was broadcast that evening, all of the jurors walking around this site and every single one of them identifiable. And of course, that was a contempt ruling. It aborted the trial. The jury was discharged. And the journalist who was responsible for this and the cameraman spent a week in the cells full of mosquitoes in Rockhampton to use the expression in Australia, purge their contempt. So that's a much, much more typical example of the way the law of contempt will be used. And it will be used in the similar way here, because you have views in this country. Jury views are very, very important part of a trial when the physical location is relevant to facts and issue in the case. Another smaller example that you will sometimes see is it can be governed under the jury legislation in some countries, but in many Australian states, this is also part of contempt, is when employers will not release an employee to to serve on a jury. This is very, very bad behaviour. Sometimes it'll be the Jury Act, but in Queensland, when I was in practice, it was dealt with through contempt. And the man who was my pupil master, he's deceased now, but he later went on to become Supreme Court judge. He ordered the employer in question who did this into the courtroom in shackles. No. Juries are actually really important, and Australia is a rich country. So, for example, the employer is fully compensated for the salary of the employee. For example, people who travel to Australia notice it's a filthy rich country. It's like going to the Middle East, and you really notice that. So they are properly compensated in Australia. You don't have the arsiness that you see over here. So keep that along with Gavin's information and Max's information, which is very much about all the stuff in newspapers and Lucy Letby and Tommy Robinson and all these high-profile cases. That's only a very small part of it. A really big part of contempt of court is protecting the institution of the jury, which, in my view, is very much part of the crown jewels of the common law.
Thank you, Helen. Sean.
As we know, Charlie Kirk was shot dead last month, and he was killed on a Wednesday. 2 days later, on Friday morning, President Trump went on Fox News and said, quote, "With a high degree of certainty, we have him in custody." He went on to say, "I hope he gets the death penalty." And then channeling his inner authoritarianism, he said, the trial should be the following day. In China, they do have quick trials. Now, later on the Friday, the Utah governor gave a press conference. And as you may remember, he began this press conference by saying, "We got him." He then named the suspect, that's my word, the suspect, Tyler Robinson. And he went on to say, this is the governor, remember, that bullets were found which had been inscribed with certain sayings which implied a political motivation. We were told that this man had confessed to the killing and that he was wearing the same clothes as had been shown in that photograph, which had been broadcast a day earlier. We were also told that he'd messaged his roommate with highly incriminating admissions, such as that he needed to go and retrieve his rifle. And we were essentially told as well that Kirk was murdered for political reasons whilst exercising his right of free speech. The governor concluded his press conference by saying this man was full of hate. Now, none of this, of course, would have happened in Britain, but it gets even more interesting because then we have the FBI director later on the same day, Friday, who thanked law enforcement officers and Tyler Robinson's family for bringing him in. And then later on the Friday, the vice president, J.D. Vance, also thanked law enforcement officers and said, "I do believe we have the shooter in custody." And then the following days, we were given further information about how the father of Tyler Robinson had persuaded Robinson to hand himself in. We were shown pictures of him, his home and his family, the background to Robinson and the background, including the politics of his family members. And we were told about his roommate, a male partner named Lance Twiggs, who we were also told was trans. Now, I mention all of this because, of course, none of this, well, not nearly none of it, would have been disclosed in Britain. And if it had been disclosed, then there would almost certainly have been contempt of court proceedings brought, and perhaps even more seriously, the defence would have had a decent shot at saying there can now be no fair trial, and therefore no trial at all. So what does this mean? Does it mean that really America is no better than China and has got no regard for due process? Or does it tell us something else? It's worth pointing out, by the way, that these sorts of comments haven't just happened under the Trump administration. This is fairly par for the course when someone is a suspect in America. And the reason for that is because of their constitutional arrangement. The First Amendment prevents the state from curtailing media outlets from reporting on a case. So it's essentially open season in America. There are, I think, 2 points which arise from this very different approach that Americans have as compared to ourselves. The first is that they have a very strong and important understanding of the right of free expression. And that is important in these sorts of cases because once you start curtailing that, you damage public trust in institutions, because essentially what happens in Britain is that it is only the authorities who are allowed to decide what information they give out to the public. And that, as we have seen in a number of recent cases, particularly over Axel Rudakubana, has given rise to a great deal of concern about how we are being manipulated. And that's why I think free speech exists, so that we can have greater faith in those who are giving us information. Also, when there's an information vacuum, it is far more likely to be filled with speculation that may be wide of the mark, and possibly with conspiracy theories. The second point I would make as well in defense of the American system is that they trust the good sense of jurors to be able to make decisions on the basis of information that they are given in the crucible of a courtroom, and to disregard all of the noise that may have been happening outside. I'm not, by the way, advocating the American system, but I think it's worth thinking about and recognizing that there are problems with the way we do it.
Thank you very much.